Hello, everyone. Before we begin, I'll share just a couple of procedural things. You'll notice that the chat function has been disabled. Throughout the presentation, please instead use the Q&A function to post questions to our speaker. We will make plenty of time at the end of the webinar to discuss your questions. You'll also notice at the end of the webinar, there will be a survey shared in the chat, shared on the screen through a QR code, and sent to you via email. Please make sure to take the survey. Let us know what you liked. Let us know what you'd like to see in future webinars. We'd love to hear your feedback. You'll also notice that this webinar is being recorded and will be posted to Ava's YouTube channel shortly, so you can revisit and share this and all of our previous webinars. After the introduction, I'll post that link in the chat. Without further ado, welcome to the Alliance Against Violence and Adversity's Webinar Wednesdays. I'm your host, Dr. Sarah Yersich. With Ava, I'm an early career researcher and lead on the webinar series. And outside of that, I'm the co-director of the Frieda Center for Research on Violence Against Women and Children, housed in the School of Criminology at Simon Fraser University. I'm joining you today from the unceded traditional and ancestral territory of the Coquitlam First Nation. And on behalf of AVA, I want to begin by acknowledging that, on a national level, we encourage all Canadians and visitors to Canada to learn about the Indigenous peoples of the lands on which they live, work, or visit, and become engaged allies together. We, as Canadians, in the spirit of truth and reconciliation, respect the self-determination of First Nations, Métis, and Inuit peoples, and their rights and responsibilities in cultures, languages, and the pursuit of wellness. The focus of today's webinar is survivors' rights in the criminal justice system, reclaiming power, demanding change. We are joined by Carrie Lowe, founder of Carrie Lowe Training and Consulting. Carrie is a sexual assault survivor and accomplished activist and advocate for survivors' rights in the criminal justice system in Nova Scotia and across Canada. Carrie, thank you so much for joining us today.
Thank you so much for having me. Hi, everyone. Thanks for joining. I'd like to give a shout out, Sarah. Thank you for that lovely introduction. Glad you could all be here today. So again, my name is Carrie Lowe. I come to you today as a survivor and as an advocate. And through Carrie Lowe Training Consulting, I also have a Survivors for Change and Empowerment program, which is a community-based resource for survivors. We have a social media platform. We also provide legal advocacy. I'll get more into that work that we do because right now that we're doing all of that work voluntarily. I also want to acknowledge that I'm joining you today from Chiboucto in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people. This land is covered by the peace and friendship treaties, which did not involve land surrender. Instead, they affirmed ongoing relationship and responsibilities. As we gather during National Indigenous History Month, I want to recognize June as a time to honor the histories, cultures, resilience, and ongoing contributions of First Nations, Inuit, and Métis people across Canada. It is also a time to reflect on the continuing impacts of colonization and our responsibilities within that history. I also want to honor the enduring presence, strength, and contributions of African Nova Scotia communities. Their roots in this region span more than 400 years. That history includes survival and leadership, as well as resistance of generations of anti-Black racism, displacement, segregation, and structural discrimination. In naming this place and these histories, I want to recognize that colonial and racial violence are not only historical facts. They continue to shape our institutions, including justice, healthcare, and social services. And because we are meeting online today, I also recognize that each of us is joining from a different lands and communities. I invite you to reflect on the territories you are on, the histories they hold, and our shared responsibility to address ongoing harms within the systems where we work and live. So why are we here? We are gathered here because listening alone is not enough. This presentation is about sexual violence, institutional betrayal, and the way systems can deepen harm rather than reduce it. I'm speaking as a survivor who has been failed by the legal system and from a truth many survivors know too well. We are told that we have rights, only to discover that those rights can be conditional, difficult to use, weakly enforced, or quietly undermined by the very institutions that claim to protect us. I am not here as a lawyer or a technical policy expert. I am here as an expert in my own lived experience and in the patterns I have witnessed alongside other survivors. I believe in survivor-led change, and I believe listening is only the first step. If institutions listen, take notes, and then continue as before, that is not a trauma and violence reform practice. It is another form of harm. Sorry. The Office of the Federal Ombudsperson of Victims of Crime work helps to show why this matters at a systemic level. In 2024 to 2025, the office surveyed 1,000 survivors of sexual violence, launched a national systemic investigation into how survivors of sexual violence are treated in the criminal justice system, and reviewed extensive stakeholder, court, and policy materials. That scale matters because it shows that these are not isolated incidences. They are patterns across jurisdictions and across survivors' encounters with police, prosecutors, courts, corrections, and the complaint systems. My hope is that from this session moves us from awareness to accountability and action. Awareness alone can become another way institutions absorb survivor testimony without changing their behavior. Today, I want us to connect the personal to the systemic. That means asking what happens when reporting leads to re-traumatization, what it means when rights exist mostly on paper, and why survivors must be understood not only as complainants or witnesses, but as truth tellers, leaders, and experts in what real justice requires. When systems fail, the damage is not only procedural, it is not only technical, it is deeply human. And that is exactly why it must change. On paper, the Canadian Victim Bill of Rights marked a significant step forward. It followed years of advocacy by victims and survivors who understood that protections in Canada were often inconsistent, fragmented, and shaped by geography or by the people handling the case. In 2014, the federal government introduced Bill C-32 to establish a national statutory framework for the victims' rights and amend related federal laws. Bill C-32 received royal assent on April 23, 2015, and most provisions came into force on July 23rd of that same year. That mattered. For the first time at the federal level, victims of crime were guaranteed rights to information, protection, participation, and restitution, a promise of dignity, voice, and accountability. But the promise was not widely understood. From the Office of the Federal Ombudsperson, Victims of Crime, fulfilling the promises of the Canadian Victim Bill of Rights 10-year progress report, released earlier this year, noted that only 17% of adults surveyed knew about the Canadian Victim Bill of Rights before being asked, and even though 81% said it was important to know about them. The Bill of Rights sets out 4 core rights for victims of crime in Canada. The right on request to information, the right to protection, the right to participation, and the right to request restitution. It also gives victims the right to complain when a federal department, agency, or body infringes or denies those rights. But having a right on paper does not always mean experiencing it in practice. A survivor may request information and still struggle to get clear answers, have a right to protection and still feel unsafe or unheard, participate and still see little change, or seek restitution and still carry the real costs of the violence that they suffered. The complaints process has similar limits. Federal agencies must review complaints and make recommendations, but those recommendations aren't binding. And the Act does not create a general right of appeal when the rights are not respected. Furthermore, these rights are not protected across jurisdictions. Most provinces, when survivors enter the justice system, are dealing with the provincial system. So services are being offered at the provincial level, victim services, the Crown, police. If you have to make a complaint about your victim's rights, you cannot make a complaint to the federal level. You must make it at a provincial level, which varies across jurisdictions. It is not a uniform system. That is why I describe that these promises on paper, meaningful in practice, but too often, fragile in practice because they depend on discretion, timing, and whether institutions choose to honor them in a survivor-centered way. The issue then is not whether these rights exist in law. They do. The real question is whether survivors can use, enforce, and rely on them when it matters most. The question leads to the gap between federal recognition and practical delivery. The Bill of Rights created a federal framework and set a national floor for victims' rights, but provinces and territories deliver most frontline victim services, operate day-to-day support, and shape how those rights are experienced. So while rights are federal, their lived reality often depends on provincial system, programs, and policies. Rights without remedies. This creates a gap between recognition and realization. One might think you have the right to information, but in the Act, it actually is worded that you have the right to request information. You have the right to request protection, participation, and restitution. And they only feel real when systems provide updates, explain the process, support safety planning, assist with victim impact statements, and connect survivors to the next step. That is why automatic information matters. So they are not obligated to provide this information. You need to request that information, and not always will you get that information. Oftentimes, when survivors, including myself, going through the system, it's our first time. We don't know what we need. We are at the mercy of those around us to tell us what it is that we're looking for. The Office of the Federal Ombudsman Victim of Crime found that 98% of stakeholders and survivors should be informed about their rights automatically when they report a crime. That is the central tension. The Bill of Rights was an important legal milestone, but it was not enough in its own way. A right is only meaningful as the system that delivers it. If rights are diluted in practice, delayed in implementation, or dependent on inconsistent services, survivors are left with a framework that sounds stronger than it often feels. That unevenness is reflected in stakeholder feedback. Protection, restitution, and complaint rights were rated less effective than information and participation rights. Sorry, I lost my spot. That is why I describe these as promises on paper, meaningful in practice, but too fragile in practice because they depend on discretion, timing, and whether institutions choose to honor them in a survivor-centered way. The issue then is not whether these rights exist in law. They do. The real question is whether survivors can enforce and rely on them when it matters most. The question leads to the gap. So again, the Victim Bill of Rights gave Canada language a victim's right, but language alone does not guarantee justice. Rights must be accessible, understandable, and enforceable where survivors actually move through the system. 10 years after the Victim Bill became law, the federal ombudsperson of victims of crime has emphasized the same concern. Victims and survivors in Canada are still waiting for enforceable rights. In its 10-year progress report, acknowledged progress but found that victims' rights remain largely enforceable and call for concrete reform. Without an effective remedy, a right can become symbolic rather than protective. If survivors cannot compel institutions to honor their rights, challenge violations effectively, or obtain meaningful consequences when those rights are ignored, the law may create the appearance of justice without delivering it. The Act itself contains those limits. Section 27 confirms that victims are not parties to the criminal case. The case remains between the Crown and the accused. A victim may be central to the facts, the harm, and the human consequences of that offense, yet still have no independent standing to direct the case, file motions, or intervene. Section 28 adds that a breach of rights under the Act does not create a cause of action or a right to damages. So in plain language, if a survivor's rights are ignored, the Act does not give them a direct route to compensation or a court order remedy on that basis alone. Further, Section 29 provides that a court decision or order cannot be appealed solely because a victim's rights were breached. Even serious procedural failures generally cannot overturn the outcome of a criminal proceeding on the basis alone. Together, these provisions show the limits of legal enforceability. No independent power to direct these prosecution, no direct claim for damages under the Act, and no appeal based solely on a breach of the rights. That is why the ombudsperson's warning matters. Rights do more than just sound good. They must be able to change outcomes, correct violations, and constrain institutional disregard. When rights exist without remedies, survivors are left with recognition without power, promise without protection, and justice without accountability. In 2018, I survived a drugging, kidnapping, and game rig by multiple strange men in Nova Scotia. What followed was not only trauma from that night, but years and years of harm caused by the systems that were supposed to protect me. I reported within hours and underwent a forensic exam. Police did not go to the assault location to collect evidence. My clothing was not picked up for 10 days, and only after I followed up. I was subjected to 4 video statements of that night, re-traumatizing having to go over that statement again. I felt blamed instead of believed, and later learned key paperwork and testing and clothing had not even been sent for testing till almost a year later. When I tried to complain, my complaint was dismissed on a technical time frame issue, forcing me into a judicial review. By 2019, media coverage made my case public as an example of systemic failure in sexual assault investigations. I kept using the proper channels, but still was shut out of information about my own complaint. A former lead investigator later told me police had not believed me and that he had been told not to investigate and to make me go away. I persisted. In 2020, I filed a civil lawsuit against Halifax Police and the RCMP. The Nova Scotia Supreme Court had ordered my police complaint to be reheard, and the province later extended the police complaint process here in Nova Scotia from 6 months to 1 year with municipal police. In 2021, moving through the criminal justice system, the first person was arrested in February of 2020. In 2021, I had to hire a lawyer to remove a publication ban that I did know existed and had not consented to. That same month, CBC's Carrie versus brought my story to national and international audience. And as well, the month later, the first criminal trial never happened because the accused was murdered just days before the trial. In 2022, a second man was charged, and I continued pushing forward for institutional accountability and still having to go through yet another criminal process. During the end of 2022, I had co-founded with other Canadian victim complainants across Canada, My Voice, My Choice. This was an initiative by survivors for survivors to challenge publication bans imposed without meaningful survivor consent. And in 2023, the second accused was in 2022, a second person was arrested. And in 2023, the second accused was acquitted because the court said he could not be clearly identified. For me, that outcome reflected how early investigative failures can affect the end of a case. At the police review board hearing just months later, evidence confirmed many of the failures I had been raising for years. My clothing was not promptly sent for DNA testing. Police did not search the alleged assault scene. I was told to package my own clothing as evidence. A nurse testified. She interrupted my initial interview in the hospital because of the questioning, appeared blaming and badgering. And a former investigator came forward as a whistleblower, and he testified he was told to drop the case because officers believed I was lying. In 2024, the review board found no procedural fault by Halifax Regional Police. That conclusion did not match what I lived. Delayed, missing evidence, blaming question, and years of fighting to be heard. By 2025, my advocacy had expanded beyond the case to gender-based violence, including intimate partner violence and survivor safety in Nova Scotia. The pattern is clear for us survivors. I reported, I cooperated, I complained, I testified, I waited. And in return, I faced delayed, lost evidence, blaming questions, procedural barriers, institutional defensiveness, and an official finding of no fault. It has been 8 years, and I still have yet to receive any accountability for the harm, the sexual violence harm, nor the harm of the officers. That is why I say the harm was not only the original violence. It was living inside a process that kept reopening the wound. From reporting to re-traumatization, we often tell survivors to report. To trust the reporting is the first step towards justice. But for many survivors, reporting is not where the trauma ends. It's where the trauma enters the system. What should feel like a path to safety can become a path of disbelief, delay, blame, and exclusion. The ombudsperson report is clear. Survivors need more than a process. They need dignity, protection, participation, and rights that can actually be enforced. And protection is not only physical, it's also psychological. It is about whether the system protects the survivor's dignity, voice, and sense of safety. In my case, the trauma did not stop with the assault. It continued again through the missed evidence, harmful questioning, exclusion from police reviews, years of delays, and processes that recognized harm without naming it, and zero accountability through police complaints process systems. That is re-traumatization. The original violence is not only remembered, it is repeated through the institutional response. And that is why institutional betrayal is not random. It happens when systems have the power to protect, but choose opacity, discretion, and self-protection instead. And this is why survivors' rights matter. Because without enforceable rights, survivors are asked to survive the violence and survive the system. For me, institutional betrayal is not by accident. It is what happens when a survivor turns to a system for protection and that system responds. oftentimes with delayed processes, blame, disbelief, exclusion, or self-preservation. The response does more than fail someone. It creates a new harm. It lays a second injury over the first. When survivors are told to come forward and trust the process, then that process mishandles evidence, questions credibility, and shuts people out or refuses accountability. It teaches something else. The violence may end, but the abandonment does not. For me, the assault was the first harm. The response became the second. I had to fight not only to survive what happened, but to survive how the system handled it. This is where continuous traumatic stress helps explain that experience. Trauma cannot become post when danger, uncertainty, and lack of protection are still present. The fear, exhaustion, distrust, and constant scanning are not personal failures. They are rational responses to an environment, my environment, that still feels unsafe to this day. That is why this is structural. Institutions often protect their own legitimacy more fiercely than people who come before for help. Until that changes, survivors carry two burdens: the trauma of violence and the trauma of being harmed again by systems that were supposed to make the justice possible. And not every survivor meets the same system. And not every survivor is believed in the same way. The Ombudsperson report says survivors' experiences are shaped by intersecting identities, including race, gender, disability, language, jurisdictions, and immigration status. So credibility is never assessed in a vacuum. It is filtered through power, bias, racism, ableism, colonialism, poverty, language barriers, and geography. Some survivors are more likely to be believed and protected. Others are treated as unreliable, complicated, or disposable. This is something I experienced. That is not a personal failure. It is a structural inequality, and the numbers show this too. Indigenous women face much higher rates of violence, and people 4 times the rate. And people with disability experience violent victimization at nearly 3 times the rate of non-disabled people. Then the system adds more barriers, communication gaps, inaccessible processes, uneven services, and the rights that exist on paper but are hard to enforce. So trauma and violence-informed practice can not only ask what happened to you, it also has to ask what structures decided whether you would be heard, protected, or left behind. Because if a trauma and violence-informed system ignores inequality, it may recognize pain, but it leaves power untouched. When we talk about police and courts as if they are neutral machines, we often talk about police and courts as if they are neutral machines, as if the harm goes in and justice comes out. But many survivors know it does not feel that way. When survivors encounter a system that narrows the story, extracts testimony, prioritizes procedure, and treats survivors' needs as secondary, the Ombudsperson report makes it an important point. Criminal justice professionals have wide discretion over how victim rights are implemented. That means a survivor's experience can depend on who they happen to meet. One officer, prosecutor, judge, administrator, or set of assumptions about whose pain counts. And when rights depend on discretion, they stop feeling like rights. They feel like permissions, temporary, conditional, uneven, and easy to withhold. The report also says victims are too often treated as objects of the law and not full subjects with rights of their own. Going through the justice system, for me, it didn't feel like I was being treated as a human. I was just a witness to my crime and my body a piece of evidence. That there is a myth That is, sorry, there is a myth that there is justice in this system. That procedure equals fairness and institutional neutrality equals safety. But if survivors provide the pain, the proof, and participation while institutions keep the power and control, then what is being protected is not justice. It is the institution's belief in itself. I have used the term justice system throughout this presentation on my slides, but in everyday life, when I talk about the justice system, I call it the legal system. A system built to protect itself. Again, these institutions often protect themselves and their procedures, reputation, hierarchy, discretion, and the legal culture that calls this neutrality. The Ombudsperson tenure report shows that this is built into the Bill of Rights because they exist on paper, but responsibility timelines, remedies, and consequences are completely missing. Under sections 27 to 29, victims have no cause of action, no right of appeal when their rights are denied. In practice, survivors can be told they have rights without having a meaningful way to enforce them. I remember when I first learned about the Victim Bill of Rights. My case, I reported in 2018, and it wasn't until 2021 when someone had to mention the Victim Bill of Rights. I didn't even know. I had lawyers then. I went to my lawyers. I said, why didn't anyone tell me that I had rights? And basically, I was told, you do on paper, but there's nowhere to hold them accountable. That is the institutional protection in legal form. Again, we see the same thing in police complaint process systems, in policing institutions. We see this all the time where we have these high rates of 94 to 98% of police complaints that are deemed unfounded. Survivor justice requires more. Enforceable rights, named responsibility, independent, truly independent oversight, and consequences when institutions fail. And survivor-centered language matters because dignity, safety, choice, and trauma and violence-informed practice matters. But survivor-centered language can still leave power in institutional hands. A system can say it centers survivors while still deciding what counts as harm, safety, participation, and justice. Survivor-led means survivors help define priorities, shape accountability, design responses, and influence a system that affect their lives. This is not only about compassion, it's about governance. Participation without power is not meaningful participation. We are experts in our own lived experience. We are the users of these services. We know what needs to change. The shift is not about abandoning survivor-centered values. It's about making them real, but by shifting authority, ensuring survivors are helping lead the change. Performative reform sounds compassionate, but avoids shifting power. It offers language, visibility, and promises while leaving the legal structure mostly unchanged. Transformative change asks what must be legally, structurally, and culturally different for survivors to experience rights as real. The report also calls for automatic, proactive, plain language information so survivors are not forced to navigate trauma-saturated systems alone. The choice is simple: reforms that sound survivor-centered or reforms that redistribute power, create remedies, and make institutions answerable. We need systems where survivors are able to make choice. We need new systems like restorative justice. And where you can come in. This is where responsibility shifts to all of us. Survivor justice is built in classrooms, clinics, policy tables, law offices, community organizations, and in everyday conversations. Moving from awareness to action means refusing the myths that make harmful systems comfortable. False neutrality, symbolic justice, and unenforceable rights. Action looks different depending on our roles. Teaching consent as dignity, researching institutional harm, advocating for court supports, building trauma-informed services, and designing enforceable law and policy. Awareness is not the goal. The question is not whether we care about survivors. It's what we are willing to change for them. As I close, I want to hold this thought. As I close, I want to hold this, though, a trauma and violence informed lens. Survivors are not the ones who need fixing. The system is broken. Harm is not only interpersonal, it is structured through institutions, policies, legal systems, colonial histories, racism, sexism, ableism, and other forms of unequal power. Again, a survivor-led approach recognizes survivors are the experts. They're the knowledge holders. They're the leaders in transforming the systems that harm them. The question is not how survivors can become more acceptable to institutions. The question is how institutions must change when survivors are believed and followed. Survivors are not broken. They have become navigating broken systems that normalize secondary victimization, ration dignity, and call symbolic rights protection. Justice cannot mean justice cannot mean asking survivors to survive broken systems better. It must mean survivors require these systems to become answerable. We are not broken, systems are. As we move into the end of this presentation, I ask you to start reflecting. What will you do differently after today? How will you use your role to support survivors? And commit, what is the one change that you will champion today? I further want to bring to the attention of a current bill, S-236, an act to amend the Victim Bill of Rights. It held its first reading in October 1st of 2025. This is a reasonable action that everyone can take. You can contact your MP, ask to champion enforceable victim rights, automatic information sharing remedies, and implementation. Call and write to your MP, support Bill S-236. Send a short personal email or request a meeting. Ask for a clear commitment to support this bill. Organize collectively, coordinate letters, host a teach-in, share a brief, and resource survivor-led groups. For one concrete next step, support Bill S-236. Ask your MP to help make victim rights enforceable. Thank you.
Carrie, thank you so much for sharing all of that with us and for your fantastic presentation. I do
Thank
want to
you.
highlight to the attendees that the Q&A is open if you have questions. But in the meantime, Carrie, I do have a couple of questions for you while we wait to see if some questions are going to come in. Is that all right?
Yes, please do. I'm hoping for the questions because I couldn't fit the meat and potatoes in this presentation.
I imagine a lot will come in, and also you do have the podcast coming up. Just a quick
Yes.
advertisement for those in attendance. There will also be a podcast. So Carrie, can you talk a little bit about how it is to navigate all of this amazing work you do as a survivor advocate?
How do I advocate?
Yeah, how do you navigate being a survivor
Oh,
and an advocate?
oh, again, so, going back to my experience again, so in 2018, when I first reported, I was alone in the process. I had a victim service worker, was not giving my, would not giving my victim bill of rights. There was a key problem in my case, though, is because of, again, I don't find all this information out till years later, but in the first 6 months, sorry, 3 months of my investigation, I would constantly call my victim services with the police. What is going on with my case? At one point, she told me, she's like, Carrie, I've been a victim services worker for 10 years and I've never seen a case like this. There is no updates on your file. So she could never tell me what was going on with my file. The police weren't updating any information. And then 6 months into my case, she retired, and I didn't have a victim services worker after that. So I was alone in the process. And looking back, I've reflected a lot going through this process multiple times that I've spoken out about it and asked, how did I get through it? I still to this day can tell you that the first 3 months, it was just, I don't know how I got through it. I was a mother. I knew I had to get up and every day and be a mom, but I had no support. I had no help until I reached out. The Elizabeth Fry Society, the executive director, her and I met, and I disclosed to her what was going on in my life. And I remember her jaw just dropped, and she was like, "Ah." And that was the first time I think I felt validated because for 3 months I was going crazy. Like, should investigations go like this? They didn't pick the clothes, and this has come to haunt me years later, as I've always said, like I've watched, CSI and, Special Victims Unit on TV, like none of this is making sense to me. So when she validated that harm, that is when I finally had support. But again, this is somebody who usually deals, the Elizabeth Fry Society, she was somebody who usually dealt with women and gender diverse folks who were the accused in criminal cases and not the victims. Although my story resonated with so many, right? So it was also a learning process for her. Um, so really, for myself, going through the system, it became a full-time job. I couldn't work and I could only function with everything to do with my case. And that is how I learned the system by default, by going through the system, by, experiencing all of these barriers and these challenges and navigating my way through that and advocating for myself. Today, now, post that when I started Survivors for Change and Empowerment and providing legal advocacy, that was one of the missions is I wanted to be able to be I wanted to be there for someone else because I didn't have that. I didn't have somebody who went through the system, who knew what it was like, who knew the challenges, the barriers, the right questions to ask, the resources to ask for, who to talk to. And that's what I wanted to provide for others. So I did create Survivors for Change and Empowerment and provided legal advocacy. I did have funding for the first 2 years. Unfortunately, with all the funding constraints that we're seeing across, Canada, I still do it on a volunteer basis, certainly not at the full-time level that I was doing. But yeah, so again, it's, frustrating, I think, for me still as a survivor and, seeing that here we are 10 years after these, Victim Bill of Rights, and it's still that we have to request information. It's not automatically given to us. And you know what, a colleague of mine and friend, she always says to me, when I'm ever going through difficult times, what can I do for you? That has been a question that has been throughout my experience for the last 8 years. And I can tell you, anytime that I have to go against the system, there's another court hearing, there's another, trial. I have, a civil case that's still proceeding. I'm not quite yet done in the system. But for 7 years, there was always something happening. And it would always create a lot of isolation and anxiety and unknown, always leading up to these dates. Dates have always been like a thing for me. And I was asked every time through those 7 years, what do you need? And I never knew. I never knew. I could not identify what it is I needed. because everything was new. It was always a new turn, a new system, a new, Um, but I will say for myself, I think one of the things I do like to share with people, is going through the process is challenging. And I have to say that one of the hardest things I have ever done, and probably the most traumatizing, was going through that police review board hearing,
Oh,
and yeah, sorry.
I was going to say, I can't even begin to imagine. Absolutely.
Yeah. So I don't recommend, again, going through some of these processes. It's extremely expensive, uh, drug out and extremely traumatizing when, again, we're fighting against a huge system, that prioritizes public, perception. We can't, you know, we can't be doing a bad job. So again, it's very disheartening. I have not received justice, and I don't think I will ever receive justice.
And that raises something for me that justice is such a big word, and we always call it the criminal justice process. But have you heard that recent shift to calling it the criminal legal system? And if you have, do you find that's more apt in terms of characterizing what you've experienced?
So I did mention it in my talk a bit earlier. And it's funny, I had, criminal justice system all over my slides. I spoke about it. But in reality, that's not the language that I use. It's not the language that anybody around me who has been, you know, um, subject to the system. We do call it the legal system.
Yeah.
That's what it is. And I can tell you, and I can't speak for every survivor. I cannot, but I do know that, you know, um, I have met other survivors who have had quote unquote justice. They have had their cases proceed. They have been, successful, I guess we'll use that term. There has been a conviction, but they too are still struggling with that. What does that mean? That's that they still don't feel like they had got justice. So again, I think it's a buzzword.
Yeah.
Um, it's definitely a legal system.
Absolutely. And a question came in from the audience that's kind of along the same lines. Kawai says, "Thank you so much for your presentation, Carrie. Given the failures of the criminal justice system, I'm wondering what your thoughts are on a restorative justice approach to addressing sexual violence."
Yeah, it's funny. I've been waiting for this moment to be asked this question. So again, I have not had a lot of privy to restorative justice processes or knowledge. I'll say this though, from what I do know, I think for me as a survivor going through the system, that if I were to change it, if I had a magic wand today, I would have choice for survivors. And I think restorative justice is a viable and much needed choice for survivors. I think restorative justice can work um, in certain circumstances. Now, I do want to talk about this. I don't think for myself in my case it wouldn't have been an option. Um, but I support survivors. I support whatever a survivor needs. Um, and I'll add this, with that is we need to have options and we need to have choices, and all of them need to be honored, and all of them are good choices. Not reporting is a good choice. And I think, a common thing that has been asked to me over the years is, would I ever do this again? Would I ever go through the justice system? And I clearly want to say a big no. I would not go through the justice system. I would not report.
That is such a powerful and important message to how very much the criminal justice or legal system fails survivors. Another question has come in that says, in the context of evidence gathering for crimes like this, taking multiple statements, then reviewing them, even in caring and well-functioning legal systems, might be seen as a necessary step to uphold high evidentiary standards. How do you think the legal system can balance the risk of re-traumatization while upholding high evidentiary standards to ensure convictions for offenders?
So there's two parts to that. So again, I so we have statements because that's separate than evidence collection. And if we're thinking about evidence, I assume the question is around like, material things, tangible things. So again, I believe that there isn't a priority in specific sexual assault cases when it comes time to the police actually collecting evidence. Um, it was a theme throughout my case. It's been a theme throughout others. But I do think the more evidence, the better. I think, and I've heard different things about like sexual assault kits and how they don't determine consent, but you know what, they can provide a story, they can back up what a survivor is saying. um, I even believe that there's limitations within a sexual assault kit. Swabbing, I think every area should be swabbed. Now when we talk about statements, that is where it differs. So again, here's the thing when it comes to statements. A statement should be made if someone comes to report, that statement should be taken immediately, as soon as possible, at a safe place where that survivor wants. They should not have to go to a police station. But that is so key and that's important, and it should be done almost immediately, especially in the first 24 hours, not 3 days later, 4 days later, a week later, because our memory changes. And when it comes time to multiple statements, absolutely not. And this is what I'll tell you. And also, and this is in part of a sexual assault examination kit as well, because they take a story. So once you have multiple statements, everything changes in your mind. And I have to give you some lived experience with this, with answering this. So I remember I spoke to the nurses, whatever. Then I had my first video statement 3 days later. And then, that first week or second week, I remember the lead investigator at the time, called me up. He got the video. He actually noted two people in the bar that were around me that evening, and he disclosed their names to me. The first thing I do, I Google. And now my memory is tainted because now I'm looking at these people on a screen, you know? And so then three more statements happen. Like I'm getting multiple statements. And these aren't statements like, oh, we have follow-up questions. This is tell me what happened that night over and over and over again. And this is the problem with that. There are going to be discrepancies. As you know, the legal system is not caught up with how trauma in the brain works either. And this is the problem, is because those inconsistencies are honed in on. That's the police hone in on them, the Crown, the defense. We are expected to remember every single detail. As we know, that is not humanly possible. So I want to, mention some things that had happened to me. My statements were all basically the same. Events happened, da da da, but these little inconsistencies started happening with what color t-shirt somebody was wearing. It went from white to blue to red because I started remembering things differently. I was exposed to pictures and my memory was now storing things differently. So when I finally got to a criminal process that proceeded, the second person charged, I remember sitting down and meeting with the Crown. And, the first thing he said to me, they said to me in preparing is, Carrie, there's little inconsistencies within your statement. And, so I have to, they can't tell you what to say. So I had to prepare myself. How am I going to answer that on the stand? Because those inconsistencies are what is honed in on. And that is why so often that we have, uh, not being believed, stories changing, these rape myths that still exist, in the system. And, So when it comes to statements with a victim, there should be one and one only, and it should be immediately. I don't think there should be one following unless it's a complex case and, they have to ask a follow-up question to something, but I wouldn't support multiple statements at all. Evidence collecting, yes. Lots of evidence collecting, which does not happen. And I think this was so pivotal in my case because I clearly remember, and again, the system then, told me I watched too much CSI and expect, my case to be handled like, TV. But I clearly remember telling the officer on day 3 when I finally got in, like, did you go to the trailer? Like, I was so like, did you go to that trailer? My shoe was there, my under was there. I didn't have that when I left. That was so important to me. And I will never forget what he said. He was like, "Oh, well, we don't have to go there. We know you were there, right? Because the cab picked you up from there." But that doesn't mean anything. That doesn't determine the story I'm telling you. I lost my shoe and underwear. You know, uh, there should have been a warrant. They should have searched that trailer. That is all corroborating evidence to back up my story that this had happened to me. So yeah, I hope that answers your question. Yeah.
That was a very thorough answer, so thank you. And I think it's always also a very powerful insight for folks to understand where the gaps are in
Yeah.
gathering evidence versus what happens when someone gives multiple statements after a little bit of time passes or after you're given additional information.
Hmm.
So, as the last question before we wrap up, I know that I mentioned we are going to have a podcast recording with Carrie right after this. So you'll find her health podcast episode shortly with Carrie. But Carrie, can you also share a little bit more information on your other podcast that you did? I believe it's called Carrie Versus.
Yeah. Yeah. So you know what? I think I will talk about this after, but I talked about a publication ban. This is another harm again that we face in the system. And again, so grateful that I was part of that movement and that change. Because I will never forget how traumatizing that was for me to know um there was a publication ban on my name, knowing I had already been, vocal. Um, so I'm sorry, I just had a brain fart. Repeat the question.
No, that's okay. Just a bit more information on your Carrie Versus podcast,
Right.
what they can
Okay.
expect, and
I know.
just
I'm
a
like,
plug.
this pub band story
Yes.
means something. I know it's leading to something. So the podcast. Okay, so this is, very important. So again, my case was proceeding through the criminal justice system. Back in 2021, before, we advocated for amendments to pub bans. What historically had been happening with pub bans is at that first court hearing, victims and survivors aren't at that first court hearing. And at that first court hearing, Crown prosecutors were, as part of their process, put a publication ban on this case, right? Again, I support publication bans. They're very much needed in the system. It protects a survivor's identity. Absolutely support these. But I don't support how they were being done. So first, accused, his first, try, shows up in court after I don't remember what it's called, reading of the charges, whatever. They put a publication ban on victims in sexual assault cases. And what that meant is nobody could talk about me and that I was connected to this case. I couldn't talk about me. I could not publicly identify that I was the victim in this specific case. So when I found that out, so again, he was charged in 2020. We're now a year and a half later, and one thing that I have always been throughout this, regardless of how it may look, I am so honest and transparent about who me and what I'm doing. Because if I want them to be transparent and honest with me, I have to do the same. So I had been working after my story broke in 2019. got a lot of media attention, and I had multiple people reach out and wanting to do a podcast. At that time, I already had a connection with Maggie Rar. She was somebody very important to me. I didn't want to meet someone else. Again, someone else to tell my story. So I reached out to Maggie and I'm like, Maggie, I'm getting offers for a podcast, but you know what? Was this something that you would take on? So she did. So this started the ball rolling on the podcast. And so we had been working on this podcast for a year. Charges laid, I had a court update. So it was July of 2021. And I won't forget this. So it was, Crown, meeting with the Crown. And I proposed that we meet because we had, this court case coming up in the fall. I was always the one initiating meetings. And I also wanted to talk to them because I wanted to disclose that I'm working on this podcast. I wanted to be transparent about it. And I wanted to say, I'm doing this. Do you have any input, feedback, anything? So I clearly remember being in that meeting with two crowns, and they did have concerns. The first concern was, Carrie, if you talk about this publicly, if you say anything about that night, that is now counted as another statement. Again, let's talk about evidence. So that again could be another statement, because if I'm public, and then it goes to court, defense can say, well, you said this in this, story or news or whatever. So I assured them, you know what? No, I had already been public in 2019. So anything that had to do with that night was pre-recorded from 2 years earlier. I was just talking about the harms that I had been facing all of this time through the police and the system. So they were like, okay, no problem. We have no problems. They didn't tell me about a publication ban. They knew and didn't tell me. So we had court September 2nd. I got a phone call September 1st, the day before, and it was Maggie from CBC. And she called to say that the Crown Prosecution Office just sent a letter to CBC to notify them that they are aware that they are working on podcasts with Carrie Lowe, and that we cannot launch it because there's a publication ban on my name. So not only did they know that this had been on for a year and a half, they knew in that meeting, they didn't tell me, they didn't contact me, they contacted the media. That was harmful. Anyway, so fast forward, I go in, I get this publication ban done. So that is how the podcast came about. I then had to go, even to have this launched, it was basically like the 12, the 11th hour. It had to be late because this publication ban, I had to have a lawyer. I had to fight for my rights to have this lifted. And I'll never forget what the judge said, because again, this was part of our advocacy efforts in amending. Is the judge said to me that he asked the defense, like, are you okay with like the defense, like the accused? He had standing. The judge said, are you okay with her lifting her publication ban? Like, this is to protect me, not him. His name, could be out there. Anyway, they didn't oppose. And then the Crown did not oppose. But the only reason the Crown didn't oppose is they forced me to get independent legal advice and to know what my legal, quote unquote, repercussions that could happen from going public. Satisfied with that, they were not opposed. And the judge said to me that day, he was like, Miss Lowe, I will now call you Miss Lowe, because you are not, they will not call you by name in the system if you have a publication ban. So he's like, I can now call you Miss Lowe. Your publication ban is now lifted, but I will let you know that if the Crown opposed, I would not have lifted that publication ban today. And that was devastating for me.
Yeah.
Yeah. So again, the podcast. So that sort of lead up to the podcast. Again, was there a specific question around the podcast?
No, just a
Like
little bit
what?
more information on it so folks who
So,
were here today can find it, know
so
what to look for.
I will say this, though. I will say this. So now I want you all to know that it's like a cliffhanger. Like you don't know what happens. A lot has happened since that podcast came out. And again, like there isn't a follow-up podcast right now. I am writing a book. But what I do want to say is that, you know, I think now looking back, I think um I would really caution people about going public. When I look back on everything that I had been through, there were consistent harms like throughout. And again, like the podcast was one of those things. It's like you don't have control over your narrative. You don't have control over your story. Even though it was very successful, it won an award. I think looking back now, I would do it in a different way. I would do it where I had power, where I had control, where it wasn't with, mainstream media. You're not compensated. They're you know, reaping the benefits of this podcast, but I'm not, on my story. And there were, not huge, but there were like little discrepancies. It wasn't an RCMP, it was an HRP. So there were mistakes. And someone like me, you know, like I am like dot I's, cross T's, this is sort of what advanced me as an advocate in my own case, being able to even get through this is I took notes. I'm very thorough. I want everything to be correct. The facts, have to be straight. So again, difficult, but also I think the broader aspects are that people identify with me in that, and I reached survivors like internationally. I had people reach out from all over the world, and to me, that was powerful, and that made it worth it. Um, and I do want to add one thing. We talked earlier about the justice system and what justice looks like, and one of the things I want to say for me, I think, I quote unquote won't get justice, but for me, I think, reclaiming my power back has been justice, right? Me being in control of, you know, when I want to talk about my case, when I don't want to, when I want to do a news story, when I want to do a podcast. I think when your choice, as a sexual assault survivor is taken from you, and then it's taken from you all through the system, right? You don't have choice through the system at all. Um, that's my justice. That's my reclaiming my power is my justice for me. Yeah, I think that's important to note.
That is so powerful and so beautifully said. And I think also a wonderful note to end on. And Carrie, thank you for sharing your story, for sharing your work with us, for sharing your time and your wisdom. I, Ava, and I'm sure all of the attendees here are incredibly grateful. So thank you so much.
Thank you so much, and thanks everyone for coming.
Our pleasure.